It's my pleasure to moderate this panel on enhancing access to justice for families through new lawyering models. And on this panel, you're going to hear from people who are actually implementing some of the innovative models that we've researched and talked about. And because these panelists are implementing recommendations that we made in our book, I thought it might be useful to start with a short summary of the book Jana Singer and I have written. It's called Divorce from Reality, Rethinking Family Dispute Resolution. And in this book, we take a look at some of the dramatic changes in the processes surrounding family dispute resolution over the last 30 years. I'm sure many of you are familiar with them. We begin with a review of the critique of the adversary system that really took hold in the 90s. As many of you know, critics of the adversary system argued that it was backward-looking, too win-lose. It was an approach that exacerbated and prolonged parental conflict. They also argued that it did little to teach parents how to manage that conflict and how to work with each other after the conflict was over. So all of this harmed children and undermined family law's principal goal, which is to foster the best interests of the children. What we call the paradigm shift in family dispute resolution was a response to this critique. It replaced the law-oriented and judge-focused model with a more collaborative and interdisciplinary regime that de-emphasizes legal norms and encourages parties to take a greater role in resolving their disputes. It uses new processes and tools like mediation, parent education, parenting plans, and new personnel like mediators, parenting coordinators, and custody evaluators to resolve conflicts in families. So the book looks at this new regime and asks whether it responds to the needs of 21st century families. And our answer is a qualified no. While it may be an improvement over the adversary system, the new regime is built largely around divorcing nuclear families, a model that fits poorly with the more complicated realities of today's disputing families, who include, among others, many non-marital families. The new paradigm also largely fails to acknowledge that some parents and children need the protection afforded by traditional legal processes and authoritative decision-making, something Melinda referred to. We also find that the legal profession has been slow to respond, both to the skills needed to operate in this new regime and to the virtual disappearance of lawyers in family court. As a result, the majority of today's disputing families must navigate a complicated and tiered system without access to legal advice. And we, of course, believe this jeopardizes durable and just results for many families, particularly low-income families. So we made a number of recommendations in our book, including moving some disputes out of court, developing new models of delivering legal services, and new approaches to legal education to train future lawyers in this new regime, which brings me to our panel. The panel bios are in your packet, so I won't give an extensive introduction of each presentation. But I will give a short one before each presentation. So I'm going to start with Suzy Eckstein to my right, who's a partner with the law firm of Oakley and Eckstein in Montgomery County, Maryland. She's been one of the leaders in the collaborative practice movement in DC and Maryland, and has also been involved in a project to extend collaborative practice to low-income families, which has been particularly, I was just telling her, a wonderful experience for the students in my clinic. So she'll talk about that this morning, and we'll start with Melinda. Each speaker is going to speak about 10 minutes, and then we'll have a lot of time for discussion. Thank you.